I just want to apologize to you and your court. I'm sorry that I disrespected and embarrassed you.
Violation of the bond condition, but just the judgment of having a child blow into the Soberlink. That's a messed up judgment. That's the only way I can, messed up being a legal term. I don't even know how you get there.
Troy Gaines, Senior Assistant Public Defender representing Ms. Reed. And would you please state your name for the record, ma'am?
Ashley Reed.
And just so Your Honor is aware, she does have her mother here for moral support.
Pardon?
Her mom is here for moral support. This time, we are asking to adjourn the PCC, but to address bond violation. In terms of the bond violation, at this time, my client wishes to vet. She indicates that she did, in fact, relapse, that and that she has been in custody now since a week ago today. And so we're asking that the court consider taking her and sentencing her to time served for the bond violation. Because, as I don't know if the court is aware or remembers, she knew that she had relapsed. She had gone through her insurance to Henry Ford Hospital in Jackson, who at the time was recommending outpatient treatment. She did explain to them that because of the relapse, that she may, in fact, have to be incarcerated. They indicated that they would still be able to have a place for her upon her release, and that if necessary, they could get her into inpatient treatment. Again, this is through her insurance. So we're asking if the court would consider releasing her with credit for the days served, reinstating her bond, placing her, if deemed appropriate, on scram tether, and allowing her to go into treatment through her insurance, and provide, if the court wanted her to provide documentation of that appointment by Wednesday so that she could get that in, to Your Honor, she'd be able to do that. I'm sorry.
I have a couple of concerns. Certainly there's the violation of the bond condition, but just the judgment of having a child blow into the Soberlink. I don't know, and I understand what you're saying regarding some of that, but that's a messed up judgment. That's the only way I can, messed up being a legal term. I don't even know how you get there.
I think you saw her nodding her head in agreement that was messed up judgment. There are, I want to be careful with my words just because I'm not sure who all may have access, but there are other extenuating, triggering circumstances in the household as related to her personal relationship.
Okay.
And she, that were part of the relapse and the triggering for that. And she is trying to get out of that situation. She has a license in medical billing. She's worked in that field before, actually over 20 years in that field.
This is where the defense strategy becomes much clearer. Counsel is not disputing the relapse. Instead, the argument is shifting toward whether continued incarceration is necessary or whether structured treatment can manage the risk. But Judge Simpson has identified a more serious concern than alcohol use alone. The judgment involved in allegedly having a child participate in the alcohol monitoring process. That matters because bond conditions are designed to test compliance and reliability, and attempting to circumvent monitoring can make a judge question whether less restrictive supervision will actually work. Notice how the defense responds. Counsel introduces treatment availability, employment history, family support, and difficult circumstances in the home. Those facts may support rehabilitation, but they do not erase the violation. The defense therefore needs to convince the court that the relapse was a setback that can be controlled rather than evidence that Reed cannot safely comply with bond. Would treatment plus scram monitoring give Judge Simpson enough protection here? Or did the alleged involvement of a child fundamentally change how the court has to evaluate her judgment?
And she had just started a new job, a better job that she hopes will position her to be out of the situation that is triggering. And they are holding it for her right now. They were aware that she had this case pending.
All right, respond.
Your Honor, last time that we were here, the people expressed their extreme concerns over the defendant's behavior. I understand she's admitting to having a relapse. I'm not sure if she's going to admit having the child blow into the Soberlink. I do think it's worth noting, and I would like the court to just have it in its mind that her Soberlink blow was a .083. So this wasn't as though we had one drink or two drinks. This is drinking. And it's of concern to the people that was the point that we got to. I believe last week we discussed that she had been approved for intensive outpatient. And I don't recall what Ms. Gaines said on the record a few moments ago, and I apologize if it was going to be inpatient or outpatient, but this does, in my non-medical opinion, screen for inpatient. The history of what I've seen. The concern of the people is I don't know much about the Henry Ford thing, and I would like to learn more before I make the agreements. So at this point, I'm not agreeing to the request for release to treatment, but I will leave it in the court's discretion. And I hope that the court will address any further questions it has of me or anything else.
And I know that my client wishes to speak so that you can hear from her. I did just want to clarify my words that I'm focusing on the relapse because there would not have been any engagement of the child absent that is the whole, that the alcohol issue is the whole issue. And by relapse, I was not at all saying that she had had one beer. That is not what she had had half a glass of wine. I was not trying to imply that by using that word.
And then people don't think that Ms. Gaines is trying to mention.
Yeah. So she's and she is not minimizing that. She is a single parent. And he has not been in any trouble for 12 years. So she is really hoping to turn this around so she can get back on the track she was before being in this relationship that has triggered all of these, the relapse.
What do you want to tell me, ma'am?
I just want to apologize to you and your court. I'm sorry that I disrespected and embarrassed you. I probably don't deserve a second chance. But I need to prove not only to you and the court, my family, my kids, but myself. I was clean for 9.5 years. This domestic violence case in this relationship, I was diagnosed with borderline personality disorder. I don't know if you know, but it's been a struggle. And I've really focused on that. And I knew as soon as I got triggered by him again, I ran to get help. And I just hope you give me a second chance to prove to you that this is not me.
Reed's statement gives Judge Simpson something important to evaluate: accountability. She apologizes, acknowledges that she may not deserve another opportunity, points to 9.5 years of sobriety, and explains that she sought help after being triggered. Strategically, that is far stronger than denying an admitted violation or minimizing the relapse. But there is still a weakness. Explaining what triggered misconduct is not the same as demonstrating that future compliance is assured. The prosecutor has already emphasized a Soberlink reading of .083 and the circumstances involving the child. Those details push the court away from viewing this as merely a technical violation. Meanwhile, the defense is building a mitigation record around treatment, employment, parenting responsibilities, prior stability, and a lengthy period without trouble. That creates the central question Judge Simpson must resolve: punishment versus controlled rehabilitation. Can scram monitoring and treatment adequately address the court's concerns, or does the conduct require additional custody first? And notice Reed's language. She asks for the opportunity to prove herself. Do you think accepting responsibility strengthens her credibility enough to overcome the seriousness of how this violation allegedly occurred?
Outside of here, Judge, I coach my kid's middle school softball team. She's in travel ball. She's in travel volleyball. I volunteer at her school. I'm supposed to go on a Mackinac Island trip on the bus with her 8th grade class. Like, I'm not a bad person. It's some messed up choices lately. Drugs are not the answer. And I know that. I was clean for 9.5 years. Sorry, I didn't speak. I'm sorry.
I'll adjourn our probable cause to June 4th, 2026, 9 a.m. Defendant having admitted to the violation, I'm going to sentence the defendant to 10 days, credit 8. Defendant is to serve that balance of those 2 days. Prior to her release, defendant must be placed on a scram tether prior to. Then her bond previously will be.
Thank you.
Thank you, Your Honor.
June 4th.
Yes.
Judge Simpson ultimately chooses a middle course. Reed admitted the bond violation, so the court did not have to decide whether a violation occurred. The real issue became the consequence. Simpson imposed 10 days, credited the 8 already served, required the remaining 2 days, and ordered scram monitoring before release. That outcome reflects both accountability and continued supervision, rather than simply accepting either side's position wholesale. The defense succeeded in avoiding continued incarceration beyond that short balance while preserving the possibility of treatment outside custody. But the court also refused to treat the relapse as inconsequential. Earlier, Simpson focused specifically on the judgment involved in having a child blow into the monitoring device. That concern helps explain why immediate release without additional safeguards would have been difficult for the court to justify. There is also an important courtroom lesson here. Mitigation works best when it does not pretend the violation never happened. Reed's counsel acknowledged the relapse while presenting treatment access, employment, family responsibilities, prior sobriety, and difficult personal circumstances. Reed herself apologized rather than fighting the admitted violation. Those factors gave the judge information relevant to what should happen next. Was 10 days with 8 days credited and scram monitoring the right balance between punishment and rehabilitation, or would you have handled the violation differently? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.